Welcome to the deep dive. You're here because, well, you want to get smart, fast on stuff that matters. Today, we're kind of cracking open the world of English criminal law, specifically what happens before a trial even kicks off. Think of this as your shortcut, your cheat sheet to understanding how the legal system starts dealing with wrongdoing. And it's all drawn from, the real deal excerpts from a proper legal textbook.
That's right. So if you've ever wondered about the nuts and bolts of how the law defines these offenses or what's really going on in those first court appearances, then yeah, you're definitely in the right place. We're going to take a really close look at non-fatal offenses, things like assault, and then delve into what are called inchoate offenses.
Inchoate, like incomplete ones.
Exactly, steps taken towards committing a crime. And finally, we'll walk through what actually happens in those crucial first hearings down in the magistrate's court. The aim is really to give you a clear picture of how the legal system gets going.
Yeah, and look, we're not just going to dump a load of legal jargon on you, we promise. We've sort of sifted through the dense stuff to pull out the key definitions, the crucial mental and physical bits needed for different offenses, and what those initial court procedures actually involve. We'll definitely highlight where things get a bit tricky and maybe point at some important details that might even surprise you. Okay, so let's unpack this, starting with non-fatal offenses. At the very base level, we've got assault and battery.
Right. So when we talk about assault in, legal sense, it's not necessarily about someone actually hitting someone else. That's often misunderstood. What's fascinating here, I think, is that an assault is legally defined as an act that causes someone to expect immediate, unlawful personal violence. It's all about that feeling of threat, that anticipation of being harmed.
Exactly. Our source material had that Alex and Emily scenario, which really nailed this point. There were a few options, but the thing that made it assault was Emily genuinely expecting that immediate unlawful force. Options A, B, C, and D in that example just didn't quite hit that mark of an imminent threat, right?
Precisely. It's almost like the law recognizes the psychological impact, the fear itself.
Yeah.
And yet the source mentioned that even silence, just being silent, can potentially be an assault if it creates that fear, that apprehension.
That's right. It can. Now, battery, on the other hand, that's when the actual unlawful physical contact happens. That's the touching part, however slight.
Yeah.
So going back to Alex and Emily, the difference was pretty clear. The assault was the fear of being hit. The battery would be the actual unwanted physical contact itself. It's subtle, maybe, but really important legal distinction. And of course, the law also considers if there are legitimate reasons for the action. Those are the defenses we won't go deep into today, but they exist. Right, defenses. Okay, now let's sort of crank up the seriousness a bit. What happens when a simple assault or battery actually results in someone getting hurt? That's where aggravated assault comes in, isn't it? Section 47.
Exactly. Section 47 of the Offenses Against the Person Act, 1861. This covers assault occasioning actual bodily harm, or ABH. And what's key to grasp with ABH is the level of injury needed. The actus reus, the criminal act itself, is basically any injury that genuinely affects the victim's comfort or health. It can't just be something, super fleeting or trivial.
So not just a quick sting.
Probably not. The old case, R.V. Miller, made it clear that even things like a bruise or maybe some swelling can be enough to count as ABH, depending on the circumstances.
Okay, so it doesn't have to be like a major injury necessarily, but here's where I found it really interesting, the mens rea, the mental part. For ABH, the person only needs to have intended or been reckless about committing the initial simple assault or battery. Is that right?
That's absolutely right. They don't actually have to have meant to cause the ABH itself, the harm that resulted. Yeah, it's like the law says, look, you started something unlawful, so you're kind of on the hook for the consequences that followed, even if you didn't specifically intend that level of harm.
That's a really crucial point. It shows the law is concerned with that initial wrongful act. Okay, so moving up the scale again, Section 20 of the same act. Unlawfully and maliciously wounding or inflicting grievous bodily harm, GBH.
TBH.
GBH sounds, well, grievous. It means really serious harm, right? And wounding isn't just any cut either. It has a specific legal definition.
That's correct. Legally, a wound requires breaking both layers of the skin, the dermis and epidermis, so a scratch usually wouldn't count, but a deep cut would. But GBH itself is broader.
Yeah.
It just means really serious harm. What counts as really serious can depend on the victim and the context, but it's a significant injury.
And the word inflict here is important, isn't it? How has that been understood?
It is, and it's evolved. Initially, way back, there was a case, R.V. Clarence, which suggested you needed direct physical force to inflict harm. But that view got overruled later by R.V. Wilson, which said inflicting GBH could include situations where someone's actions indirectly lead to serious harm, even without direct violence.
Right, and that understanding has broadened even more since then. I remember reading something about inflict, sometimes meaning basically cause, particularly for psychiatric harm, cases like Ireland and Burstow.
Exactly. Those cases were really significant.
Yeah.
They clarified that, especially concerning psychiatric injury, inflicting GBH can simply mean causing it. It shows the law adapting to understand harm beyond just physical blows.
Mm-hmm.
And this broader view has some pretty major implications today. For instance, knowingly transmitting a serious disease like HIV can be considered GBH, as the court decided in R.V. Dika.
But then without a physical attack.
Yes, because serious harm is caused through their actions and their knowledge of the risk. It really shows how the law tries to, well, keep up with different ways serious harm can occur.
That's quite something. Okay, so what about the mental state for Section 20? The Act uses the word maliciously. What does that actually mean here? It sounds quite, evil.
It does sound loaded, but legally, maliciously here has a specific technical meaning. Thanks to cases like R.V. Cunningham and confirmed for Section 20 in R.V. Parmenter. It means one of two things. Either the person intended to cause some bodily harm, doesn't have to be serious harm, just some OR they were subjectively reckless. That means they realized there was a risk that some bodily harm might occur from their actions, and they went ahead and took that risk anyway.
Okay, so they saw the risk of some harm, not necessarily the GBH itself.
Exactly. The case DPP-VA confirmed that. You only need to foresee the possibility of some harm, not the really serious GBH that actually resulted. So it's about recognizing a risk of causing some injury and deciding to take it.
Got it. So for Section 20, you either meant some harm or you saw the risk of some harm and did it anyway. Now let's tackle the most serious one we're covering today, Section 18. Unlawfully and maliciously wounding or causing GBH with specific intent. That sounds like a big step up.
It absolutely is. The actus reus, the action bit, is similar to Section 20. It involves wounding or causing GBH. But notice the wording difference. Section 18 uses causing GBH, which strongly implies that indirect ways of bringing about serious harm are definitely covered. Again, thinking back to Ireland and Burstow, that distinction between cause and inflict matters. Section 18 covers causing GBH full stop.
But the real difference, the key thing setting Section 18 apart is the mens rea, right? The with specific intent part. What does that mean?
Absolutely. That's the crucial distinction. To be guilty of Section 18, the prosecution has to prove that the person had a clear, specific intention. Their direct aim or purpose was either, 1, to cause grievous bodily harm, so really serious harm, or 2, to resist or prevent a lawful arrest.
Okay, so it's not just foresight of some harm like in Section 20.
No. It's a higher level of culpability. They must have specifically intended that really serious outcome, or intended to resist lawful apprehension. It's not enough to just see a risk. It has to be their actual goal. That's why Section 18 carries a much heavier potential sentence up to life imprisonment. It reflects that deliberate aim to cause maximum harm or seriously obstruct justice.
Right, okay. So we've journeyed from just the fear and assault to actual contact and battery, then causing harm with differing levels of intent or recklessness in ABH in Section 20, and finally, that specific deliberate intention to cause really serious harm or evade arrest in Section 18. That progression makes a lot of sense. Okay, let's switch gears now. Let's explore this intriguing area you mentioned earlier, inchoate offenses. It sounded like crimes that weren't quite finished.
Exactly. Think of inchoate offenses as the law stepping in before the main crime is completed. It happens when someone takes significant steps towards committing a crime, or actively helps someone else plan or prepare, even if the final crime doesn't actually happen. It basically recognizes that the intention combined with those preparatory actions can still be a danger and should be illegal in itself.
Mm-hmm. And the first one is attempt to commit an offense. Our source material talks about this line. When does planning cross over into actually attempting a crime? Where's the threshold?
The key legal test is whether the action is more than merely preparatory to committing the full offense.
Just thinking about it or making very early vague plans isn't enough. There needs to be a concrete step, something that puts the plan into motion and gets pretty close to the final act. Okay, more than merely preparatory.
It shows a real commitment to carrying it out.
We had that multiple choice question about Jonathan and attempted burglary. He damaged a door. Why was that considered more than just preparation? Why was it an attempt?
Well, damaging the door was a direct action aimed squarely at getting inside unlawfully. It wasn't just, say, buying tools or looking at the house. A jury could look at that act breaking the door and reasonably conclude that it showed Jonathan's clear intent to enter and commit theft or criminal damage inside. The fact he didn't actually get in doesn't matter for the attempt. Damaging the door was a significant step, putting his plan into action. That's why C was the right answer there.
Okay, that clarifies it. It's about taking that direct step towards the illegal goal. Now, the other big piece here is assisting or encouraging an offense under the Serious Crime Act 2007. This seems a bit more complex, with the different levels depending on the person's state of mind.
It is, yeah. The 2007 Act tried to create a clearer, more structured approach than the old common law rules. It sets out 3 main offenses based on what the person knew or intended when they helped or encouraged. First, there's Section 44, intentionally encouraging or assisting an offense. This needs proof that the person specifically intended their actions to help or encourage the main offender commit the crime. They have to want the crime to happen and be trying to help make it happen.
Okay, specific intention to help. Then Section 45, that's encouraging or assisting an offense believing it will be committed. How's that different?
Here, the focus shifts slightly from intention to belief. The prosecution needs to show the person believed the main offense would actually be committed, and D believed their own actions would encourage or assist it. Their primary motive might not be wanting the crime to happen, but they act knowing or believing it will, and that their act will contribute. It's about acting with that specific belief about the crime and their role.
I see. And the last one, Section 46, encouraging or assisting offenses believing one or more will be committed. That sounds even broader.
It is. This covers situations where someone assists or encourages, believing that one or more offenses of a certain type might be committed. Maybe they don't know exactly which one or exactly when, but they believe their actions will help facilitate at least one of them. It covers assisting more general criminal activity.
Right. And for all 3 of these, Sections 44, 45, and 46, what's the actual action required? The actus reus.
The actus reus is simply performing an act that is capable of encouraging or assisting the commission of one or more offenses. The key word is capable. The act doesn't actually have to succeed in encouraging or assisting. It just has to have the potential to do so.
This sounds, well, really similar to the whole idea of accomplice liability, aiding and abetting that we see elsewhere in the law. How closely related are they?
You're absolutely spot on. They're very closely linked conceptually. The traditional common law rules on accomplice liability, aiding, abetting, counseling, procuring cover, similar ground. Both are about holding people responsible for their involvement in crimes committed by others. And we saw that connection in the MCQ about Alice Bennett, the one selling equipment. Answer D was correct because her liability as an accomplice depended on her knowing, or at least contemplating, the type of crime her tools might be used for. It reinforces that need for some kind of mental link to the potential crime.
So whether you're trying to do it yourself or helping someone else, the law takes those steps very seriously, even if the main crime doesn't happen. Okay, let's pivot now. What happens right at the very beginning of a case? Those first hearings in the magistrate's court. Our source says this is where all criminal proceedings start in England.
That's right. Every single criminal case begins its journey in the magistrate's court. Now, for the really serious stuff like murder or those Section 18 GBH cases we talked about, the magistrate's role is quite limited. They basically handle the initial admin, the first appearance, maybe deal with bail, and then formally send the case straight up to the Crown Court for trial.
Like a sorting office, almost.
In a way, yes, for those serious cases. It's a quick initial check-in before it moves to the higher court.
And the source breaks down offenses into 3 main categories, doesn't it? Summary only, either way, and indictable only. Can you break those down for us?
Sure. So, summary-only offenses are generally the least serious. They can only be tried in the magistrate's court. Think common assault, like in that Emily Johnson detention question.
Yes, the 24-hour limit one.
Exactly. Because common assault is summary only, the police custody time limits are generally shorter. Hence, answer B being correct about the 24 hours. These cases stay entirely within the magistrate's court system.
Okay. Then, either way, offenses. These sound like they have more flexibility. They can go to either the magistrate's court or the Crown Court.
That's right. This middle category includes offenses like Section 47 ADH, Section 20 GBH, and theft. There's a crucial hearing called the mode of trial hearing, or sometimes allocation hearing, where a decision is made about which court is more appropriate for the trial.
And that Jonathan Smith plea before venue question touched on this, didn't it, about sentence indications?
Yes. If the magistrates give an indication of the likely sentence, if the defendant pleads guilty at that stage, they are bound by it if the person does plead guilty. But if the case later goes to the Crown Court judge isn't bound by what the magistrates indicated. That was answer A.
Right. And finally, indictable only. These are the most serious, and they have to go to the Crown Court.
Correct. Offenses like murder, rape, robbery, and Section 18 GBH are indictable only. For adult defendants, after their first appearance in the magistrate's court, they are sent directly to the Crown Court for trial by judge and jury. There's no choice. The magistrate's court simply doesn't have the power to try these cases.
Okay, that classification is really fundamental. Now, before these hearings really get underway, something crucial for many people is getting legal representation, often through legal aid, or a representation order, as it's formally called. How does someone apply for that at the magistrate's court stage? What do they look at?
Good question. There are basically two key tests. First, the interests of justice test. This looks at factors like, is the person likely to lose their liberty if convicted? Is the case complex? Can they understand the proceedings themselves? Do they need help cross-examining witnesses? Things like that. Second, there's a means test, which assesses their financial situation, income, capital outgoings, to see if they can afford to pay for a lawyer themselves.
And that Oliver Thompson question highlighted a couple of things here.
It did. It showed that someone receiving certain benefits, like universal credit, will usually automatically pass the means test. And if there's a real risk of losing their liberty going to prison, then the interests of justice test is very likely to be met. So, answer B was correct there. It's all about ensuring fairness, particularly when someone's freedom is on the line, or they can't navigate the system alone.
Makes sense. Legal aid is obviously vital. So what actually happens during that very first hearing itself? Can you give us a quick rundown? What's the procedure like?
Well, it's often quite brief and primarily administrative. The court confirms the defendant's identity and the charges against them. Key decisions about the next steps are made. This could involve sorting out legal aid if it's not already in place, setting dates for future hearings, like the mode of trial hearing if it's an either-way case, dealing with bail, or, as we said, formally sending indictable-only cases up to the Crown Court.
And the defense lawyer is obviously involved at this stage.
Oh, absolutely. The defense solicitor is crucial at this first hearing, advising their client on the charges, their rights, the procedure, bail, and the potential pleas.
You mentioned the mode of trial hearing for those either-way offenses. The source also talks about plea before venue. Are these the same thing or linked? How does that work?
They're very closely linked, usually happening at the same hearing for efficiency. Plea before venue comes first. The defendant is asked to formally enter their plea guilty or not guilty to the either-way charge. After they've entered their plea, the magistrates then undertake the mode of trial or allocation procedure. They decide if they think the case is suitable for summary trial in their court, considering things like the seriousness of the specific facts and their own sentencing powers.
And what happens if they decide it is suitable for them and the defendant pleaded not guilty?
Then the defendant gets the choice. They're asked if they consent to having their trial in the magistrate's court, or if they elect to choose to have their trial in the Crown Court before a judge and jury.
Wow, okay. So the defendant actually gets a say in where their trial happens for these either-way offenses, provided the magistrates agree it's suitable for them.
Yes, that's a key right for defendants facing either-way charges.
That seems like a really big decision. What might make someone choose the Crown Court over the Magistrate's Court? What are the pros and cons they'd be thinking about?
There are several important factors they'd weigh up, usually with advice from their solicitor. A big one is the jury. Some defendants feel a jury of 12 ordinary people gives them a better chance of acquittal than magistrates, who are legal professionals or trained lay people. Also, Crown Court procedure is generally seen as more robust for challenging prosecution evidence. There are more formal rules, potentially pretrial arguments about admissibility of evidence, things like that.
More opportunity to scrutinize the case against them.
Potentially, yes. And finally, Crown Court cases tend to move a bit slower, which can mean more time for the defense team to prepare their case thoroughly. These are all strategic considerations. Of course, the potential sentences can be higher in the Crown Court too, so it's a complex calculation.
So the path a case takes really starts being mapped out right from these initial classifications and hearings. It's definitely more structured than maybe it first appears.
It really is. And as our source material mentions, specific laws, sections 1920, 50A of various acts, govern exactly how these allocation and sending decisions are made, ensuring cases end up in the right place based on seriousness and complexity. That Alice Thompson question touched on this allocation process for either-way offenses, confirming the magistrate's role in deciding suitability. That was answer B.
Okay, wow. We have covered a huge amount of ground in this deep dive. We've gone from really getting the difference between assault and battery through all those different levels of non-fatal offenses, focusing on harm and, crucially, intent.
The mens rea.
Then looked at in choke rate offenses, those attempts and assisting or encouraging acts, and finally mapped out those absolutely critical first steps in the magistrate's court, the classification of offenses, legal aid, and that whole plea before venue and allocation process.
Yeah, and I think we've really hammered home how vital it is to understand both parts, the actus reus, the physical act or omission, and the mens rea, the mental state required. They're the fundamental building blocks for almost every crime in English law.
Absolutely. And it's become really clear that those initial procedures in the magistrate's court aren't just ticking boxes, they are the gateway, setting the direction for the entire legal journey that follows.
Definitely. Which actually brings up a final thought, maybe something for our listeners to mull over. Considering everything we've discussed, the different levels of seriousness, the importance of proving intent, the procedures for deciding which court hears the case, what do you think might be one of the biggest challenges in actually ensuring a fair and just outcome in any given criminal case? When you think about it, how hard is it to truly prove what someone was thinking? How vital is it that every procedural step is followed correctly? There's a lot tangled up in there, but hopefully this deep dive has given everyone a much more solid foundation for thinking about it.